Surprise! I'm back earlier than I thought. It was really quick that in that time now I decorated my car with writing the stuff on the windows for happy birthday to her, drove by to her house, drove past her house a couple times with the line of people wishing happy birthday, got home, washed my windows, and now I'm back here. So we are going to finish Kathleen Zellner's filing from October of 2019. Hey Patrick, my name is Jax West. I run Stephen Avery Project. We also have a private group called MAM Gossip. That's where we dig in deeper into the case and where we also talk about other cases. And then I also have Justice with Jax, which is my advocating for the wrongfully accused and miscellaneous other things. So, and before we start, when I'm reading, I don't typically see your comments that are over here. I've got the filing over on my other screen over here, so I will not see your comments. And I don't know if any Stephen Avery Project moderators will be on or not, because we've already been on for a long time today, and I had said I would be going on at 7:30 p.m. my time, and now it's 7 o'clock. But yeah, I want to get this done. So we left off on page 107. Let me get the link here. This is the link to the filing that I got off of Kathleen's website. So if you would like to read for yourself, there you go. You have the access to it. And as I said, this is her filing from 2019. We did find out while we were live today that the state, their response was due on Friday, but they filed today, and we found out about 4:45 p.m. I am the same time zone as it is in Wisconsin, so there'd be no way of getting it unless press has it and puts it out. So we should be able to get it tomorrow, and as soon as we have our hands on the state's response, we will go live here on Stephen Avery Project and read that and discuss and probably bitch about it. So, and if any of the Stephen Avery Project moderators pop on here, can you share this link to the live in the Stephen Avery Project group as well as the MAM Gossip? Since when I was doing it earlier today, we were having really spotty service, and it's because I set up the video to go directly to those pages as well at the same time, and I think that might be what caused all the problem. So off we go. So now we are on page 107 out of 150. If you missed the other one, there's 3 other parts that, thank you, Christina. There are 3 other parts that are up on Stephen Avery Project, and sometimes depending on how you are accessing Facebook, whether or not you're on your phone or a tablet, or you're going through the browser or the app, sometimes it's hard to find videos. So, but there is a section on Stephen Avery Project where you can find all of our videos. So there's plenty of videos there. And then we have more videos that are in our MAM Gossip group of, like, when I took the gossip group on a field trip to Manitowoc and went to all the locations. And actually we're going to be doing that again. It's just been put off because of the virus and not being able to leave. So, okay, here we go. Page 107. Oh, I need to move my microphone back up. Sorry. Despite the fact that prior post-conviction counsel recognized the need for experts, they failed to retain a single expert to review the key pieces of forensic evidence that resulted in Mr. Avery's conviction. Prior post-conviction counsel failed to detect the illegal seizure of groin swabs taken from Mr. Avery. Prior post-conviction counsel failed to retain their own experts in blood spatter, ballistics, DNA, anthropology with kerf mark specialization, forensic pathology, police procedure, and audio enhancement, who would have been able to demonstrate that all of the forensic evidence used to convict Mr. Avery was planted, as summarized infra at page 99 to 103. Both trial defense counsel and prior post-conviction counsel were ineffective pursuant to Strickland in failing to hire the above-listed experts. Their deficient performance falls below an objective standard of reasonableness. Mr. Avery was prejudiced by their deficient performance. The cumulative effect of trial defense and prior post-conviction counsel prejudiced Mr. Avery because both failed to review, quote, certain portions of discovery, unquote, provided by the state, failed to, quote, master the discovery documents, unquote, failed to independently investigate certain lines of inquiry about Bobby and Mr. Hilgas, and failed to initiate an investigation of any additional evidence or information to impeach them. The Thiel court instructed that in making a Strickland evaluation of prejudice, the, quote, totality of the representation, unquote, standard is not the proper inquiry, but rather, quote, the effect of counsel's act or omissions on the reliability of the trial's outcome, unquote. The cumulative effect of all of these deficiencies undermines confidence in the outcome of the trial and establishes Strickland prejudice. Even though prior counsel performed well on some aspects of the trial and post-conviction, it does not offset the cumulative effect of their deficiencies in failing to master the discovery, independently investigate third-party suspects, and obtain experts to undermine the very flawed theory used to convict Mr. Avery. Failure to raise ineffective claim regarding impeachment of Bobby, the killer. Prior post-conviction counsel filed Mr. Avery's blah blah motion immediately after trial and were ineffective under Strickland because they confined their ineffectiveness claim against Mr. Buting and Strang to the narrow issue of juror removal. They overlooked the clearly stronger ineffectiveness claim of trial defense counsel's failure to impeach the state's primary witness, Bobby, and other witnesses, and to hire vitally important experts to dispute the state's experts. The court in Rather versus Meisner reversed the Wisconsin State Court decision for applying the wrong standard in Strickland. The Rather court noted that Strickland is the, quote, benchmark decision for claims of ineffectiveness and provides that the Sixth Amendment's guarantee of the assistance of counsel is violated if an attorney's actions are objectively unreasonable and prejudice the defendant, unquote. The Rather court stated, quote, although the court identified Strickland as the controlling legal authority, it did not apply Strickland's framework. Rather, in assessing whether Rather was prejudiced by counsel's errors, the court required a showing of but-for causation. That is not the standard. Instead, a petitioner must demonstrate a, quote, reasonability probability, unquote, defined as one, quote, sufficient to undermine confidence in the outcome, unquote, that counsel's errors materially affected the outcome of the proceeding. In this battle of credibility, counsel's failure to make use of the witness's prior statements doomed Rather's prospects from the beginning. Had counsel cross-examined the witnesses adequately, he would have cast significant doubt on Danielle's and Bragg's testimony, which was ripe for impeaching, unquote. Prior post-conviction counsel failed to recognize the Strickland ineffective argument that should have been raised about trial defense counsel's failure to recognize the significance of Brian's statement to the police and that Brian could have been called to impeach his brother Bobby on the pivotal issue of the case, did Ms. Halbach leave the Avery property on October 31, 2005? Prior post-conviction counsel failed to raise the clearly stronger Strickland argument regarding the failure of trial defense counsel to impeach Bobby. The ineffectiveness of prior post-conviction counsel is a sufficient reason to overcome the procedural bar relied upon by the circuit court in denying Mr. Avery relief on his current post-conviction motion. These failures, combined and individually, constitute textbook deficient performance. The defendant must show that counsel's failure resulted in prejudice. In order to demonstrate prejudice, Mr. Avery must show a, quote, reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, unquote. Quote, a reasonable probability is a probability sufficient to undermine confidence in the outcome, unquote. When a defendant alleges multiple deficiencies by trial counsel, quote, prejudice should be assessed based on the cumulative effect of counsel's deficiencies, unquote. To be clear, prejudice is now not an outcome determinative standard. The focus is on reliability of the proceedings. In this case, quote, the result of a proceeding can be rendered unreliable and hence the proceeding itself unfair, even if the errors of counsel cannot be shown by a preponderance of the evidence to have determined the outcome. Here, prior counsel's deficiency has rendered Mr. Avery's trial unreliable. The sole issues at trial were the forensic evidence linking Mr. Avery to the victim and the identity of the murderer. Trial defense counsel presented no real defense to the state's forensic evidence. Trial defense counsel called 7 witnesses and only 2 experts. Mr. Avery did not testify. The jury was left only with the state's unrebutted forensic evidence and the undisputed testimony of Bobby that Ms. Halbach walked into Mr. Avery's trailer and was never seen again. All of the evidence incorporated in the Allen chart on page 99 to 103 applies to prior post-conviction counsel's ineffectiveness in conducting a significant investigation to impeach Bobby and others, and in failing to retain experts. The above listed claims are obviously stronger than the claims raised by prior post-conviction counsel. Page 112 out of 150. 5. The circuit court abused its discretion in dismissing Mr. Avery's second motion pursuant to a Wisconsin statute blah blah without requiring the state to respond or conduct an evidentiary hearing. A. Standard of review. The Wisconsin Supreme Court has ruled that a trial court may deny a motion for post-conviction relief under blah blah statute without a hearing if the motion fails to allege sufficient facts to raise a question of fact or presents only conclusory allegations, or if the motion, files, and record conclusively show that the defendant is entitled to no relief. Whether a defendant's post-conviction motion alleges sufficient facts to entitle the defendant to a hearing is a mixed standard of review. No, this is not the state's reply. That's what we're rating on, Amanda. The state's reply, which was filed today, we will get tomorrow. This is Kathleen's filing from October of 2019. So we were going over this today as a refresher before the scheduled response by the state, which is supposed to be in 2 days. But they, the state turned it in today. But they turned it in at end of work day. So we won't be able to get it until tomorrow. So tomorrow we will go over that. But at this time, I don't know what time because I don't know when we'll get it. First, the appellate court determines whether the motion on its face alleges sufficient facts to entitle the defendant to a hearing is a mixed standard. Oh, wait, I just went over that. Material facts that, if true, would entitle the defendants to relief. If the motion raises such facts, the circuit court must hold a hearing. This threshold inquiry is thus a question of law subject to de novo review. A circuit court's discretionary decisions are reviewed under the differential erroneous exercise of discretion standard. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Even if a court is disinclined to believe evidence offered by a movant, the court must is underlined, must hold a hearing before making credibility determinations. Only after a hearing is the court charged with determining the issues and making findings of fact and conclusions of law. In Roll, the defendant filed a motion for post-conviction relief. The circuit court denied the motion and the defendant appealed. The Court of Appeals reversed and the state petitioned for review. The Wisconsin Supreme Court held that, while the allegations in the petition were initially conclusory, the circuit court had permitted the defendant to supplement his allegations with an affidavit. Because the affidavit, quote, provided some support for the conclusory allegation, unquote, the Wisconsin Supreme Court held that the circuit court abused its discretion in dismissing the petition without an evidentiary hearing. In Zuhl versus State, the Wisconsin Supreme Court held that the circuit court abused its discretion because the motion set forth sufficient factual allegations, such that it should not have been summarily dismissed. Defendant's only support for his allegations was his own affidavit. The circuit court dismissed the motion, finding that the defendant's allegation was not supported by the previous trial record. The Wisconsin Supreme Court explained, quote, that is not the test. A silent record does not conclusively show that the defendant is entitled to no relief. Hi, Miley. Unquote. The defendant's burden at the first stage of the act is to present an issue of fact that, if later proven at a hearing, would entitle him to relief. The court in Allen determined that a motion contains sufficient material facts for an evidentiary hearing if it includes, quote, the name of the witness, who, the name of the, or the reason the witness is important, why, how, and facts that can be proven, what, where, when, that clearly satisfy the Bentley standard and would entitle a defendant to a hearing, unquote. As the chart illustrates, Mr. Avery has met all of the Allen requirements. And now what follows is a chart that across the top of this is who, what, where, when, why, how. And then the line underneath it says ineffective assistance of counsel, failure to hire experts. So, first person, Stuart James, blood spatter expert. Mr. Avery's blood was selectively dripped in the RAV4, was therefore planted. Mr. Avery's blood in the RAV4. Mr. Avery's blood discovered in RAV4 on November 5, 2005. And then for the why, how, it lists page 68 to 72. So now when I read the rest of these lines, I won't be saying the page. So again, now remember, in all of these, it's the who, what, where, and when. In the, why can't I think of the word now? The post down below, I can't think of the word. I've said it a million times. It says, in the course of her investigation, current post-conviction counsel has obtained affidavits from 14 experts. Current post-conviction counsel has obtained 22 affidavits from 17 lay witnesses, and current post-conviction counsel has also obtained 3 affidavits from Mr. Avery's trial attorneys. Next person is Lucien Haig, ballistics expert. Ms. Halbach was not shot through the head because the bullet had no bone particles, found on Mr. Avery's garage floor on March 1st, 2006. Dr. Christopher Palaniuk, PhD, trace expert, using a 2016 scanning electron microscope, determined that the bullet was not shot through Ms. Halbach's head and that the hood latch swab did not swab the hood latch. And this was on Mr. Avery's garage floor, and the RAV4 on March 1st, 2006 was the bullet, and April 3rd, 2006 was the hood latch. Dr. Carl Reich, PhD, DNA expert. Mr. Avery's DNA planted on RAV4, hood latch, and subkey. From Ms. Halbach's RAV4 in Mr. Avery's trailer on April 3rd, 2006 was the RAV4, and November 8th, 2005 was the trailer. Dr. Stephen Symes, PhD, forensic anthropologist. Microscopic examination should have been done to confirm suspected human pelvic bones were human, found in the Manitowoc gravel pit in November of 2005. Dr. John DeHaan, PhD, forensic fire expert. Ms. Halbach's body was not burned in Mr. Avery's burn pit on November 8, 2005. Dean Strang admits ineffectiveness in failure to hire experts with the blood stain patterns in the RAV4 during pre-trial and during trial, and the magic bullet found in the garage. This next section is titled Ineffective Assistance of Counsel, Failure to Investigate and Impeach Bobby. So, yes, I'm still reading, Andrea, I'm still reading Kathleen's filing. We don't have the state's filing. We should have that tomorrow. So this first section is titled Brian Dassey and Blaine Dassey. Brian impeaches Bobby regarding Ms. Halbach leaving Avery property. Blaine lied at trial about fire in Mr. Avery's burn barrel at the Dassey residence, November 4th, 2005. Greg McCrary, police practice and investigation expert. Hilgas and Bobby is third-party suspects. And then the dates are October 31, 2005, November 3rd, 2005, and April 23, 2006. Conrad Bates, investigator for trial counsel, admits failure to investigate Bobby at Dassey residence, November 6, 2005. Ross Colby, audio enhancement expert. Audio enhancement impeaches Sergeant Colburn. The MCSD dispatch call, November 3rd or 4, 2005. Dr. Larry Bloom, MD, forensic pathologist. Bobby lied about origin of his back scratches at the Aurora Medical Center, November 9, 2005. Next section is titled Brady Violations, Romlo, Rodant, and Dassey Yanda CD. Kevin Romlo is an eyewitness. Brady violation regarding RAV4 being planted. He saw it at the turnabout at the East Twin River Bridge on Highway 147, July 15th, 2017. Joshua Rodant, witness, impeachment regarding RAV4 planted. Avery Salvage Yard, November 5th, 2005. Denise Heidel, witness, establishes direct connection of Ryan Hilgas to crime scene. Ms. Halbach's location unknown at time of phone call, October 31, 2005. Gary Hunt, senior forensic examiner. Brady unique Veli word searches withheld from trial defense counsel. From the Dassey Yanda residence, April 17, 2018. Dr. Ann Burgess, PhD, link between violent pornography and crime. Dassey Yanda residence, April 17, 2018. Jerome Buting, Brady violation regarding Bobby computer at the Dassey Yanda residence, pretrial. Dean Strang, same as I just read for Buting. So now we're done with that. The circuit court erred in weighing the scientific evidence rather than granting an evidentiary hearing. The circuit court concluded that the, quote, defendant's experts, ... could not reach definitive conclusions regarding items of evidence without further testing, unquote. The circuit court specifically attempted to weigh the evidence about the DNA experiments performed by Mr. Avery's DNA expert on a RAV4 hood latch. The circuit court misinterpreted the statistical significance of Dr. Reich's findings and erroneously concluded that the DNA on the hood latch was deposited by sweat from Mr. Avery's hand, when Dr. Reich had stated there is no DNA in sweat. The circuit court misinterpreted Dr. Reich's affidavit to state that there, quote, is no forensic test available that can conclusively determine whether DNA was left by sweat, unquote. Of course there is no test available because there is no DNA in sweat. In order to assist the court, Dr. Reich prepared another affidavit in which he explained the misperceptions of the circuit court. Dr. Reich stated that he had sufficient independent tests to support his conclusions. The circuit court also tried to weigh the evidence about the subkey as a result of the experiments performed on it. The circuit court ignored the experiment performed by Dr. Reich of Mr. Avery holding an exemplar key and depositing 10 times less DNA than the amount detected by the WSCL. The circuit court chose to focus only on the allegation that the key was the subkey, which it is the subkey. There's no denying that. Finally, and most significantly, the circuit court completely misread Dr. Palahniuk's affidavit about the lack of bone particles and the presence of wood on the magic bullet. The circuit court claimed that Dr. Palahniuk's report, quote, is not that clear-cut, unquote. The circuit court claimed that Dr. Palahniuk did not, quote, discover all particles present on the bullet's surface, unquote. The circuit court failed to comprehend Dr. Palahniuk's statement that only, quote, if indications of bone were detected by these methods, further analytical approaches could be applied to more specifically confirm its presence, unquote. Dr. Palahniuk responded to this erroneous interpretation by stating that the court was incorrect that the entire bullet surface had not been examined for the presence of bone. The circuit court also erroneously concluded that Dr. Palahniuk's report, quote, indicates that the tests performed cannot determine what the red substance on the bullet is, unquote, and that further testing would be needed. Dr. Palahniuk clearly stated in his affidavit, quote, regardless of its identity, the texture of the bullet in the area where the droplets are observed strongly suggests that the droplet was deposited after the bullet was fired and came to rest. This material could be identified if subjected to further analysis, unquote. Clearly, if the droplets were deposited after the bullet came to rest, it is immaterial what the substance is. Dr. Palahniuk disputes the circuit court's conclusion and states, quote, this court also misconstrued my statements in regarding my observation of 2 red droplets on the surface of the magic bullet. I proffered the opinion that the color, texture, and shape of the red droplet deposits suggests that the material may be paint and that it could be tested to identify it. There has never been an issue in the underlying case that the red droplets were blood because at trial, the forensic analyst, Sherry Big Hair Culhane, testified that she had not done a presumptive test for blood, nor had she observed any stains on the bullet fragment. She also testified that she had washed the bullet fragment in a solution. The following observations all suggest that the material on the bullet is composed of paint. A, the properties of the droplets that were observed. B, the fact that bone was not detected on the bullet. C, the fact that the bullet had been previously extracted specifically for DNA. D, the fact that no indications of blood were previously noted during prior examinations. E, the presence of additional bullet holes in the garage where this bullet was found. And F, evidence that red paint was used to paint the garage, as well as objects in the garage, which would suggest a source for this bullet, unquote. Dr. Palahniuk also states, quote, though this material could be identified by sampling and analyzing the droplets, analysis that were expressly prohibited and outside the scope of my analysis of the bullet, parenthesis, the identity of the material was not pursued further due to the above listed facts of the case, which together with the lack of any prior indication of blood on the bullet suggests that these droplets on the bullet are composed of paint, unquote. The circuit court ignored Dr. Palahniuk's findings that numerous fibers were found on the bullet's surface, some embedded in wax and other embedded on the bullet's surface. There is no question that the state's theory as to the cause of death was gunshots to Ms. Halbach's skull. The absence of bone particles on the magic bullet completely refutes that it passed into Ms. Halbach's skull, as the state's expert, Dr. Jensen, opined. The circuit court completely misread Dr. Palahniuk's affidavit as requiring further testing. No such testing is necessary because Dr. Palahniuk has established that the state's contention that magic bullet caused Mr. Halbach's death is false. The circuit court also erroneously concluded that State versus Allen was inapplicable because the, quote, reports are speculative, unquote, and lack conclusions. The circuit court failed to acknowledge its errors in interpreting the expert reports and determined that the reports, contrary to the expert's own opinions, were interim and therefore speculative. 6. The circuit court erred as a matter of law in applying the wrong standard to the newly discovered evidence. In its October 3, 2017 ruling, the circuit court stated, quote, the defendant attached numerous reports to his latest motion, arguing that the forensic tests conducted in the reports were not available at the time of the defendant's trial in 2005. However, the defendant's arguments ignore an important question. Were the tests available at the time of the defendant's previous motion pursuant to Wisconsin statute blah blah, or any of the other appeals or motions filed after trial? Unquote. The circuit court ruling that in order for evidence to be new, the testing methods used to obtain it must not have been available at the time of Mr. Avery's prior appeals and or post-conviction motions is manifestly erroneous. That is not the standard. When moving for a new trial based on an allegation of newly discovered evidence, a defendant must prove 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking the evidence. 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative. If the defendant is able to prove all 4 of these criteria, then it must be determined whether a reasonable probability exists that had the jury heard the newly discovered evidence, it would have had a reasonable doubt as to the defendant's guilt. If the defendant was not negligent in failing to ferret out the evidence on which he relies, then a prior motion brought pursuant to Wisconsin statutes blah blah does not procedurally bar the claim. In State versus Brian Avery, so a different Brian, this is a Brian spelled with an I, not Brendan's brother. The defendant filed a motion under Wisconsin statute blah blah over 12 years after his conviction and argued that during that time, new technology had allowed him to develop new evidence of his innocence. The circuit court denied the motion, but the Court of Appeals reversed the post-conviction order and remanded the matter for an evidentiary hearing, concluding that the defendant had made a prima facie claim of newly discovered evidence. The appellant court applied the test discussed above from Edmonds and determined that the defendant met all 4 prongs of the test. As to the first prong, the defendant was not required to establish when the new technology was available. The defendant satisfied his burden by simply showing that the technology was not available at the time of his trial. Similarly, Mr. Avery in the case at bar has satisfied his burden by setting setting forth in his motion that the new technology was not available at the time of his trial. The new technology is as follows. We are now on page 124 of 150. 1. Dr. Palahniuk examined magic bullet using state-of-the-art technology, not available at the time of Mr. Avery's trial in 2007. Dr. Palahniuk's examination of the magic bullet and his findings have produced new evidence that is totally inconsistent with the state's theory that Ms. Halbach was shot in the head while lying on Mr. Avery's garage floor. 2. Dr. Palahniuk, using a 2016 microscope to analyze the hood latch swab in conducting a series of experiments, has offered the opinion that the swab was not used to swab the RAV4 hood latch. 3. John DeHaan, PhD, a forensic fire expert, has conducted more experiments on human cadavers than any other fire forensic expert in the world since 2012. Dr. DeHaan's experiments refute the state's theory that Ms. Halbach was burned in Mr. Avery's burn pit. 4. Dr. Reich was able, through the use of new source testing, to eliminate the following rich sources of DNA from the hood latch swab: blood, semen, and saliva. The circuit court never addressed the undisputed fact that Mr. Avery has demonstrated through Dr. Reich's experiments and source testing that the DNA on the hood latch was planted. There is no innocent explanation for the large quantity of DNA on the hood latch if blood, saliva, and semen are ruled out. The only plausible explanation is that the large quantity of DNA came from the illegally seized groin swabs, which Dr. Reich said would provide a comparable quantity of DNA as that found on the hood latch. Ultimately, the question is whether there is a reasonable probability that the jury, after hearing the new evidence, would have reasonable doubt of the movement's guilt. The question has been answered about the state's theory that magic bullet caused Ms. Halbach's death. It did not. Therefore, Ms. Halbach's DNA was planted on the magic bullet. Also, Ms. Halbach's body was not burned in Mr. Avery's burn pit. The question is not answered by simply weighing the evidence, because a jury can find reasonable doubt even if the state's evidence is stronger. This same principle is applicable to the prejudice prong of Strickland and the determination of whether the state committed a Brady violation. 7. Mr. Avery raised sufficient reason as to why these issues could not have been raised in prior motions pursuant to Wisconsin statute, blah, blah. In its October 3, 2017 order, the Circuit Court found that Mr. Avery failed to overcome the procedural bar to having his motion heard. In so ruling, the court held, quote, "There is no argument or showing of a sufficient reason as to why these issues could not have been raised in prior motions. Without such sufficient reason, these arguments are precluded from any subsequent motion." Unquote. A. Standard of review. Whether Mr. Avery's claims are procedurally barred depends upon the proper interpretation of the statute, which is a question of law that this court must review de novo. B. Mr. Avery has demonstrated a sufficient reason for failing to raise the current claims earlier. Hold on. Okay, so I just got this article. Aaron Keller wrote it, who you see in Making a Murderer. State fights Stephen Avery's attempt to get out of prison in Making a Murderer case. This is in Law and Crime, Dan Abrams. I don't like Dan Abrams. The state of Wisconsin on Wednesday filed a 130-page appeals court brief in an attempt to keep convicted murderer Stephen Avery in prison. Avery and his nephew, Brendan Dassey, became famous worldwide after their convictions were showcased in the Netflix film Making a Murderer. Attorney Kathleen Zellner is appealing Avery's conviction. Avery has since 2005 declared his innocence in the killing of freelance photographer Teresa Halbach on Halloween Day of that year. Avery said he was framed for filing a civil suit against the local Manitowoc County Sheriff's Department after its deputies and leadership botched a 1985 rape case. That case landed Avery behind bars for 18 years on a crime DNA evidence later proved he did not commit. The state's appeals court brief, which has long been delayed through requests for additional time, lays out a series of 6 issues presented by a myriad of Avery motions. See, I told you that the press would get this before anybody else. It asks the Wisconsin Court of Appeals to rule in favor of the state on all 6 issues presented. Among the issues is whether a trial judge in Manitowoc County should have allowed Avery to fight against his conviction in a piecemeal fashion through multiple motions for post-conviction relief. Another of the issues is whether a trial judge properly denied Avery an evidentiary hearing on his several new claims. One of the core of the issues, however, is a question about whether the trial judge, who is reviewing the case all these years later, made a mistake when she ruled, again without a hearing, that Avery did not suffer a Brady violation regarding compact discs of information that were identified to his original defense team but not fully turned over before trial. The CDs, Zellner has argued, contain information which could support an argument that another member of the Dassey family could have committed the killing of Halbach. The disagrees with the claim that the disc should have been turned over in full. This quote, "The circuit court found that the state turned over all of the evidence to the defense and the defense simply failed to assign it any significance and pursue it," unquote, the state now argues. Quote, "It further determined that Avery's ineffective assistance claim was conclusory and undeveloped," unquote. Zellner has argued that the original defense team, made up of attorneys Dean Strang and Jerry Buting, failed to dig into the material because the original prosecutor, Ken Kratz, told them it was not significant. The appeals court must now answer whether that alleged trickery was a Brady violation. Brady versus Maryland is the 1963 U.S. Supreme Court case which requires prosecutors to turn over to the defense evidence which could weigh against a conviction. Another of the core issues is whether Avery suffered legal harm when the state released bone evidence to the Halbach family long after the trial, but in alleged violation of state and federal law. The beginning of the state's argument rests heavily on the procedural grounds and accuses Avery and his defense team of, in essence, flailing their arms in an attempt to score a win. Quote, "Avery has embarked upon a significantly different venture than this appeal presents. He seems to erroneously believe that he is appealing the jury's determination of guilt. He further seems to believe, also erroneously, that if he can identify any conceivable alternate theory of the crime, he has disproven the state's case against him and proven the existence of the constitutional violations he alleged, no matter how insufficiently supportive, speculative, inconsistent, far-fetched, or belatedly raised his argument is. Accordingly, the bulk of his brief is dedicated to relitigating his trial defense, though he cannot seem to settle on any particular theory, because there are so many!" Unquote. Read the state's filing below. And now Lynn just sent it. So, all right. Let's mark this. We are leaving off on this one on page 126. So I'm going to end this one and we will start a new video and read the actual filing. So look for that one.